morning, everyone. Thank you for coming out this morning to be with us. We have a very special guest, Dean Erwin Chemerinsky. He is a native of Chicago, and we joke that we ordered up the snow especially for him. He has taught at DePaul, at UCLA, at USC. He was at Duke for many years. He was the founding dean at the University of California at Irvine School of Law. He is now the dean at Berkeley Law. He has been named the most influential person in legal education, and he is among, if not the, most recognized scholar in constitutional law. There's many more things I can say about him, but we have just 50 minutes of his time today. We're going to sweep him over to East Campus. And if you can join us at 12:30, the Provost is sponsoring a conversations series featuring Dean Chemerinsky, and also a panel that will include our own Professor Schwinn on free speech. So hopefully you can make that as well. Dean Chemerinsky is going to spend some time talking about the current Supreme Court term and a little bit about the Docket case that he argued, but he's going to leave plenty of time because we know a lot of you have questions that you'd like to pose to him. So without further ado, Dean Erwin Chemerinsky, thank you so much.
Thank you so much for the kind introduction and the warm welcome. It's terrific to be here. I have said to several people, walking over from the Hilton Hotel where I stayed last night this morning did remind me of why I moved from Chicago to Southern California in 1983. But it is great to be back and great to be in Chicago. I've been a law professor for 40 years now. I've never seen a term of the Supreme Court that had so many potential blockbuster cases on the docket. So Darby asked me to talk for a few minutes about this term's docket and then be glad to take questions about these cases, about the Supreme Court more generally, about recent events in Washington, D.C. There have been some high-profile events in Washington, D.C., or anything else I can do to be of use. I was trying to think about how to best cover the docket for this term, and I decided the fairest way would be alphabetically. So let me start with A, and abortion. On March 4th, the Supreme Court will hear oral arguments in two companion cases with regard to abortion, June Medical Center versus G and G versus June Medical Center. Louisiana adopted a law that said in order for a doctor to perform an abortion, he or she had to have admitting privileges at a hospital within 30 miles. If this sounds familiar to you, Texas had an identical law. In fact, Louisiana copied verbatim the Texas law. And in 2016, in Whole Women's Health versus Hellerstedt, the Supreme Court, in a 5-3 decision, declared the Texas law unconstitutional. Justice Breyer wrote the opinion for the court, joined by Justices Kennedy, Ginsburg, Sotomayor, and Kagan. Justice Alito wrote the dissent, joined by Chief Justice Roberts and Justice Thomas. All across the country, after Whole Women's Health, laws like the Texas one were struck down. In fact, a federal district court judge in Baton Rouge, Louisiana, struck down the Louisiana law in June Medical Center versus G. But the Fifth Circuit, in a 2-1 decision, reversed and upheld Louisiana law. A conservative judge, Patrick Higginbotham, dissented and said, this is indistinguishable from the Texas law. We're required to follow a Supreme Court precedent. But it upheld the law and the Supreme Court granted review. The court also granted review on the question of whether health providers should continue to have standing to raise the rights of women patients challenge laws restricting abortion. I intentionally mentioned to you the composition of the court when decided Whole Women's Health versus Hellerstedt, and Justice Kennedy was part of the 5-person majority. He's obviously no longer on the court. This is the first case to be decided by the court since Justice Gorsuch and Kavanaugh joined them with regard to abortion rights. I think the consensus of both liberals and conservatives is there are now 5 justices on the court to allow significant additional restrictions on abortion. I believe there are 5 justices on the court who will either effectively or explicitly overrule Roe versus Wade. So it's possible that the court in these cases could follow precedent in Whole Women's Health versus Hellerstedt. It's possible the court could try to distinguish Whole Women's Health versus Hellerstedt. I think it's probably likely that it will overrule Whole Women's Health versus Hellerstedt. It's possible, I don't think likely, they'd use this as the vehicle for overruling Roe versus Wade. Continuing alphabetically, let me go to civil rights. And on the second day of the term, October 2nd, 3 cases were argued concerning gay, lesbian, and transgender rights. All involved Title VII of the 1964 Civil Rights Act, which prohibits employment discrimination based on race, sex, or religion. As to sex, it says there cannot be employment discrimination, quote, because of sex. The first hour of oral argument that morning involved 2 cases that were consolidated: Zarda versus Altitude Express and Bostic versus Clayton County, Georgia. Both involved men who were fired from their jobs for being gay. They argue that to fire them based on sexual orientation is discrimination because of sex. I think a simple example illustrates why they're right. Imagine an employee named Chris. Chris has never met the employer in person. Chris and the employer talk by email and text. Chris is often referred to a husband in discussing weekend or evening plans. When the employer meets Chris, the employer is surprised to see that Chris is a man. The employer says, I don't want to employ gay people, you're fired. Well, if Chris is a woman, Chris would still have that job. But because Chris is male, Chris lost the job. Isn't that employment discrimination because of sex? The employer and the Trump administration argue that the 1964 Civil Rights Act was never meant to deal with sexual orientation discrimination. They argue that this employer would fire a gay man or a lesbian woman, so there's no discrimination because of sex. The other case argued that morning was RG and GR Funeral Homes versus Equal Employment Opportunity Commission. Amy Stevens worked for 6 years as a funeral home director for Harris Funeral Homes. She transitioned from being male to female. She told the proprietor of Harris Funeral Homes that instead of wearing the coat and tie that men wear when they're funeral directors, she was going to wear the skirt that female funeral directors wear. The employer thought about it for a couple of weeks and said, violates my religion to employ a transgender person, you're fired. She filed a complaint with the Equal Employment Opportunity Commission. It ruled in her favor. The employer appealed to the United States Court of Appeals for the Sixth Circuit. It also ruled for Amy Stevens, and the employer sought Supreme Court review. The Trump administration came in on the side of the employer. So procedurally, it's unusual. The United States government won in the Sixth Circuit, but they filed a brief in the Supreme Court titled Brief for Respondent in favor of reversing the lower court. Amy Stevens' argument is that if she were male, she would still have the job, but because she's female, she was fired. That's discrimination because of sex. The Supreme Court earlier had said that discrimination based on gender stereotypes violates Title VII. On the other hand, the employer and the Trump administration say this is an employer would fire a transgender man or a transgender woman. There's no discrimination because of sex. One other case with regard to civil rights I'll mention is the case that I argued in the Supreme Court on November 13th. I didn't argue the Docket case that I'm co-counsel, but I did argue Comcast versus National Association of African-Owned Media. It involves a federal statute, 42 United States Code, Section 1981, which prohibits race discrimination in contracting. It was adopted as part of the Civil Rights Act of 1866. My client is Byron Allen. You might have seen him perform. You might know that he owns the Weather Channel, but that's not what this case is about. He also owns 7 other cable channels. And if you happen to get DirecTV or Dish TV or Uverse, you get Byron Allen's channels. But he went to Comcast and asked them to carry his channels, and they said, no, we won't unless you do the following dozen things. He went and did them, spending hundreds of thousands of dollars, went back to Comcast, and they said, we're sorry, we don't have any more bandwidth. But they did take 50 white-owned channels in the meantime. Also, one of the Comcast officials said something very racist to him, said, quote, we don't want to create any more Bob Johnsons, referring to the head of the Black Entertainment Television Network. Byron Allen sued Comcast for violating 42 United States Code, Section 1981, race discrimination based on contracting. The federal district court, in a very short opinion without explanation, granted a motion to dismiss, And I represented Byron Allen in the Ninth Circuit, argued the case a year ago, October, and won, and Comcast then sought Supreme Court review. The question is, what's the standard for pleading and maybe even for proof under 1981? Is it enough that Byron Allen showed that race was a motivating factor? Or does he have to prove that race is the but-for cause for being denied the contract? Now, this might just sound like words, but to try to give a sense of why it matters, I'll give an example that I did in response to a question from Justice Sotomayor at oral argument. He said, imagine that somebody goes to, an African-American person, say, goes to a hotel to rent a room. And the proprietor says, I'm sorry, we have no rooms, and besides, we don't rent rooms to black people. If the complaint has to allege that race is the but-for cause for discrimination, that case gets dismissed, because we don't know that the person would have gotten the room except for race. But if it's enough to say that you can allege that race is a motivating factor, then the case can go forward, and then in discovery we can see what was the real basis for the denial of the room. Well, I've talked about abortion, I've talked about civil rights. Let me continue alphabetically and talk about DACA, the Deferred Action for Childhood Arrival Program. 3 consolidated cases were argued in the Supreme Court on Tuesday, November 12th. They were argued on my side by Ted Olson and for the United States government, for the Solicitor General, Noel Francisco. As you know, President Obama created an executive order, referred to it as DACA. It protects between 700,000 and 800,000 individuals. These are people who were brought to the United States before the age of 16. They have to be under age 30 when the program was initiated. They can't have a felony conviction or a serious misdemeanor conviction. They have to be enrolled in school, successfully graduated, or enlisted in the military or honorably discharged. President Obama gave these individuals what federal immigration law calls deferred deportation status for 2 years, which means they wouldn't need to fear being deported during that time, and they also could get a work permit. President Trump announced that he was rescinding DACA, which then make all of these individuals vulnerable to immediate deportation. Every federal district court judge to consider this found that it was unlawful because there was no legitimate reason given for ending the DACA program. This includes both federal district court judges appointed by Democratic presidents and by Republican presidents. Under the Administrative Procedures Act, the Supreme Court has said there has to be an articulated, legitimate reason for a government action. District Court said there was no reason for this, and the Ninth Circuit upheld the District Court from San Francisco. The Supreme Court granted review. The human stakes of this are enormous. We have a number of DACA recipients in my law school, many on my campus. I'm sure that's true here as well. My optimistic self believes that the Supreme Court will come to the same conclusion as the lower federal courts, that there really was no legitimate reason for ending DACA. My more pessimistic self thinks back to the travel ban case, Trump versus Hawaii, from June 2018, where the court, 5-4, upheld a travel ban that was blatant religious discrimination against Muslims. Continuing alphabetically, I'll talk about free exercise of religion in a case that was argued just last month. It's not going to get the headlines of some of these other ones, but it's enormously important. It's Espinoza versus Montana Department of Revenue. Montana's legislature adopted a tax credit program for parents who send their children to private school, whether it's a secular or religious school. The tax credit's pretty minimal, about $150 each. The Montana Supreme Court found that this violated the Montana state constitution. The Montana state constitution prohibits the state from giving direct or indirect aid to religion. Most states in the country have similar provisions. The supporters of this program said to the Supreme Court to strike down this program because it gives aid to religious institutions through these tax credits, violates free exercise of religion. Montana says to the Supreme Court, there is no program any longer. The Montana Supreme Court struck it down on Montana constitutional grounds. There's nothing for the Supreme Court to look at. here's the underlying issue. I believe that the 5 conservative justices on the court are going to take the position that whenever the government gives aid to a private secular entity, it is constitutionally required to give that aid to religious entities. That is an enormous change in the law. It was hinted at in 2017 in Trinity Lutheran versus Comer, but that was just about whether Missouri had to give aid for playgrounds to parochial schools. The stakes in this case are much higher. Next to last, going alphabetically, I'll talk about presidential power. And on March 31st, 3 cases will be argued in the Supreme Court that I think are the most important cases about executive power since the United States versus Nixon in 1974. The first of these is Trump versus Vance. A grand jury in New York State Court subpoenaed records from President Trump and others to see if there were campaign violations in the 2016 presidential campaign concerning hush money that was paid to Stormy Daniels and Karen McDougal. Michael Cohen and others revealed that money was paid, significant sums, to Stormy Daniels and Karen McDougal to not reveal that they had sexual relationships with Donald Trump. Well, that seemingly is spending money in a campaign for political advantage. The grand jury subpoenaed the records to investigate this. President Trump went to federal court to quash the subpoena. The federal district court denied that. The federal district court stressed that this isn't about what President Trump did while in office. This is about conduct before office. Clinton versus Jones was a different context, said a president has no immunity when it comes to acts prior to taking office. The United States Court of Appeals for the Second Circuit agreed. The Supreme Court granted review. The other 2 cases will be consolidated for oral argument. They're Trump versus Mazars USA and Trump versus Deutsche Bank. Both involve congressional committees that subpoenaed Trump financial records. They were in particular investigating the relationship financially between Trump and Russia, and also whether or not additional legislation was necessary. The federal district court in D.C. in the Mazars case ruled against President Trump. These are records being sought not from him, but from his accountant. The federal district court in New York ruled against President Trump in the Deutsche Bank case. Once more, it's not records from here, but records from his bank. The D.C. Circuit and the Second Circuit respectively affirmed, and the Supreme Court granted review. I think the core of the rule of law is that no one, not even the president, is above the law. I think this is what Chief Justice John Marshall meant when he said in Marbury versus Madison that we are a nation of laws, not just of people. And I think that's really what these cases are about, is whether or not we will adhere to the rule of law or put the president above the law. Finally, alphabetically, I'll talk about the Second Amendment, case that was argued the first week of December, and this is New York Rifle and Pistol Association versus Cuomo. New York City gave 2 kinds of gun permits. One was called a carry permit. It meant what it said. If you got a carry permit, you could carry your gun outside the home. The other was called a premises permit. This would give you permission to have a gun on the premises of your home or your business. And if you had a premises permit, your ability to carry the gun outside the home was limited. You could only take the gun outside the home to one of the firing ranges in the city, and it would have to be unloaded during that. You couldn't take your gun outside the city like you had a weekend or vacation home. A challenge was brought. The claim was that the Second Amendment protects the right to have guns outside the home. The federal district court in New York rejected that. The Second Circuit affirmed. New York City then repealed its ordinance. New York State adopted a law prohibiting cities from restricting people from taking their guns outside of the city. New York said to the Supreme Court, this is moot. It's a challenge to a law that's no longer on the books. The Supreme Court said, we're not going to dismiss the case, raise that at oral argument. And about 80% of the oral argument was spent on the question of mootness. As somebody who teaches federal courts, I think this is clearly moot. It's a challenge to a law that's no longer there. But I also know that the conservatives on the Supreme Court want very much to expand gun rights. From 1791, when the Second Amendment was adopted, until June 2008, not one federal, state, or local law was struck down by the Supreme Court for violating the Second Amendment. But then the court in District of Columbia versus Heller declared unconstitutional a 35-year-old D.C. ordinance to rid ownership and possession of handguns. Justice Scalia wrote for the court, but the court said only that there's a right to have guns in the home for the sake of security. The court didn't articulate a level of scrutiny. The court was clear, though, that it's not an absolute right. There have been over 100 Court of Appeals decisions since Heller. The Supreme Court has denied review whenever it's been requested. And now it has a case where I think the conservatives would like to use it to expand gun rights, but there's a real mootness issue there. So that's just a sample of what's on the docket this term. That's why you can see why I say it's such an amazing year in the Supreme Court. And with that, I'm glad to take questions about these cases, other things about the Supreme Court, or whatever I can do to be of help. Please.
What about Google versus Oracle?
Google versus Oracle is an enormously important case with regard to copyright law, and it involves whether or not interfaces to software can be copyrighted and whether or not it was fair use. And I've heard people who are experts in intellectual property say that this is likely the most important copyright case decided by the Supreme Court, if not ever, in many years. Because obviously, in order to just hook up a cell phone to the internet, there's going to take many software interfaces. Google is being sued here by Oracle for using parts of software interfaces without copywriting. So it really is, can you copyright those interfaces, and what does fair use mean in this context? Please.
Hi, so I'm wondering if you have any insight onto the potential outcome of the case Hernandez v. Mesa dealing
Sure.
with the Bivens action.
Sure. Hernandez versus Mesa was argued the same day as the Docket case, Tuesday, November 12. It involves a border agent in El Paso, Texas, who fired his gun, the bullet went across the border, and killed a teenage boy. The boy's family sued, saying that this was excessive force, and the Supreme Court has long held that excessive force violates the Fourth Amendment. I need to explain a bit about the context of the case for those who aren't familiar with it. If a state or local government official violates the Constitution, he or she can be sued under 42 United States Code, Section 1983. And so any time you want to sue a state or local government officer or a local government for a constitutional violation, you always do it as a suit under 42 United States Code, Section 1983. But there is no federal statute that authorizes suits against federal officers when they violate the Constitution. In 1971, in Bivens versus 6 unknown named agents, the Federal Bureau of Narcotics, the Supreme Court said that a federal officer can be sued for money damages right under the constitutional provision itself. Bivens involved agents of the Federal Bureau of Narcotics who broke into Wesley Bivens' home in the middle of the night, subjected him to a very abusive illegal search, and he wanted to sue them for money damages. In the Supreme Court, an opinion by Justice Brennan said he could go forward with that claim. Justice Harlan, in a concurring opinion, said for people in Bivens' shoes, its damages are nothing. It's already happened, and there should be some remedy available, and the ability to sue the United States government is tremendously limited because of sovereign immunity. And then the Supreme Court, in some other cases, expanded Bivens suits. In Davis versus Passman, the Supreme Court said you can bring a Bivens suit for denial of due process and equal protection under the Fifth Amendment. In Carlson versus Green in 1980, the Supreme Court said you can bring a Bivens suit against federal officers for cruel and unusual punishment in violation of the Eighth Amendment. Carlson versus Green was 1980. That's the last time that the Supreme Court has ruled in favor of a Bivens claim. In every case since then, the Supreme Court has narrowed the availability of Bivens suits. Justice Scalia and Thomas were fond of saying that Bivens was wrongly decided. The majority has been frequently said that it believes that Bivens should be narrowed, not expanded. Well, the context of Hernandez versus Mesa is whether there's a Bivens suit for the boy's family in suing this border agent who fired the gun across the border and killed him. Now, I think the answer to that should be clear. The border agent is in the United States. It's excess of force. Graham versus Connor says excess of force violates the Fourth Amendment. Bivens says you get a money claim under the Fourth Amendment. But remember, every Bivens case for 40 years has come out against the Bivens cause of action. Case, as I said, was argued Tuesday, November 12th. Please. Maybe if you could stand, it's a little hard to hear. So am I.
Concerning the abortion in the LGBTQ cases, do you think that the Supreme Court will take a more formalist or functionalist approach?
A more
Formalist or functionalist approach? And if they do take the formalist approach, do you feel that like they'll be missing the long-term effects of society if they do a more oppressive restrictions?
Let me start with the gay and lesbian and transgender rights cases. Did you know that every Supreme Court case in history that's expanded rights for gays and lesbians had the majority opinion written by Anthony Kennedy? In the constitutional area, Romer versus Evans in 1996, Lawrence versus Texas in 2003, United States versus Windsor in 2013, Obergefell versus Hodges in 2015. Anthony Kennedy is no longer on the court. Many think that John Roberts is going to be the new swing justice. And I think ideologically he is the median justice on the court. But if gay and lesbian transgender rights advocates want to put their hopes on John Roberts, I think it's misplaced. When Obergefell versus Hodges was before the Supreme Court, I publicly predicted that it was going to be a 6-3 decision to strike down laws prohibiting same-sex marriage with John Roberts in the majority. And I reasoned that John Roberts cares a great deal about his legacy. He'll want to be on the right side of history. And there's no doubt where history is going on this issue. I was wrong. He wrote a dissent. His dissent was angry, even vitriolic. The only dissent that John Roberts has read from the bench since coming on the court in October 2005 was in Obergefell versus Hodges. So I think that the question is there a fifth vote in favor of gay, lesbian, and transgender rights now that Anthony Kennedy has left the court? I'd like to believe there is. I'd like to think that Neil Gorsuch, who prides himself on being a textualist with regard to statutory interpretation, will say, this is clearly discrimination because of sex. But I'm not optimistic. With regard to abortion rights, I think the key question with regard to June Medical Center versus June Medical Center is, will the Supreme Court follow precedent? I mean, with regard to the admitting privileges, Whole Women's Health versus Hellerstedt is right on point. With regard to the standing issue, there's a Supreme Court case, Singleton versus Wolf in 1976, that said that health providers have standing to raise the rights of women patients. So then the question becomes, how much weight will the Roberts Court give to stare decisis, to precedent? And I'm not optimistic. I could recite the cases of the last 2 years, just the last 2 years, with the court's overruled precedent, but I'll tell you a story where I was the lawyer to explain it. There was a case that was in the Supreme Court last year called Franchise Tax Board versus Hyatt. In 1979, in Nevada versus Hall, the Supreme Court ruled that a state could be sued in another state's court. I represented Gil Hyatt and argued his case in the Supreme Court a year ago on January 9th. Hyatt is an inventor. He moved from California to Nevada in 1991. Some employees of the Franchise Tax Board were convinced it was a sham move, that he said he had moved, but he hadn't really relocated. He just wanted to evade California taxes. One of the employees of the Franchise Tax Board said very anti-Semitic things about him, said disparaging things about Jews more generally. The employees of the Franchise Tax Board, and they collect taxes in California, literally went to Nevada to his house and broke into it, tried to prove he didn't live there. They sent dozens of letters out that had private information, including his social security number. They spread false rumors about him, including those with whom he was doing business. Hyatt sued the Franchise Tax Board in Nevada State Court, pursuant to Nevada versus Hall. The jury ruled in his favor and the jury awarded him $385 million in damages. As Justice Thomas said in ruling against him, what he was treated to was truly egregious. By the time the case got to the Supreme Court last year, the judgment reduced to $100,000. The Supreme Court granted review on just one question: should Nevada versus Hall be overruled? When I argued the case on Wednesday, January 9th, 2019, I was struck by how many of the questions I got from the justices were about stare decisis and precedent. At one point, Justice Alito said to me, "How would the values of stare decisis be served by ruling in favor of your client?" And I talked about the reliance that had been on Nevada versus Hall in litigation through the country. Justice Breyer then did a 2-minute soliloquy on why stare decisis matters in the law, and he tacked on at the end, "Do you agree?" I paused for emphasis and said, "Yes." Chief Justice Roberts then interjected, "I thought that's what you would say." Justice Alito then said, "Isn't the court better off with regard to public esteem overruling decisions that it thinks are wrong rather than continuing to follow them?" I said, there are times when precedent has to be overruled. It was imperative that Brown versus Board of Education overruled Plessy versus Ferguson. But stare decisis matters in terms of predictability, stability in the law. Justice Kavanaugh then said he thinks that precedent should be overruled only if it's, quote, egregiously wrong. I said, I like that adverb. Nevada versus Hall was not egregiously wrong. On Monday, May 13th of last year, the Supreme Court 5-4 overruled Nevada versus Hall. Justice Thomas wrote, joined by Chief Justice Roberts, Justice Alito, Gorsuch, and Kavanaugh. Justice Breyer wrote the dissent, joined by Justices Ginsburg, Sotomayor, and Kagan. Justice Thomas said, stare decisis is, quote, not an inexorable command. He says, just let's wait in constitutional law. Justice Breyer defended Nevada versus Hall, but most of all, he defended stare decisis. And he concluded his dissent by saying, one can only wonder what other Supreme Court decisions are now likely to be overruled. I don't think any of the justices on the court are formalists, though sometimes they'll use formalist rhetoric. I think the justices are very much all making value choices. After all, in my case, there's nothing in the Constitution that limits the ability to sue a state in a state court. The Constitution's silent about it. It wasn't discussed at the Constitutional Convention or the state ratifying conventions. 3 times in oral argument, the justices asked the attorney on the other side, Seth Waxman, where in the Constitution do you find this limit? And finally, his exact words were, this is the best I've got. Justice Thomas, in his opinion, rejected my claim by saying it's, quote, ahistorical literalism. There's no formalism there. It's really about the values of the justices. Please.
Do you have thoughts about Chief Justice Roberts' famous statement during his confirmation process that he and other judges are just call balls and strikes? They're neutral in light of what you just said about values?
I think he should be ashamed of saying that. And I think Justice Sotomayor should be ashamed of saying justices just apply the law, they don't make the law. They know better than that. They know that everything the Supreme Court does makes the law. And it's nothing like being an umpire. Umpires are applying the rules made by others. The justices are making the rules. Everyone here knows so much of constitutional law, especially with regard to individual rights and equal protection, is about balancing. Umpires don't balance when they make their calls. I think what he was trying to do, and obviously it worked, was say, since I'm just an umpire, and umpires' views don't matter, my views don't matter, so I shouldn't have to answer any questions you have about my views. It's a wonderful rhetorical strategy. Others have used it since, but it's wrong. We all know the Supreme Court has tremendous discretion in interpreting the Constitution. Balancing is inherently discretionary, and inevitably that's going to come down to the values of the justices.
Considering Justice Gorsuch's dissent in Gundy last term, what do you think the future is of congressional delegations of power coming up to the court?
For those of you who are taking constitutional law about structure of government or taking administrative law, I think one of the biggest changes that we're going to see in the near term is the revival of the non-delegation doctrine. For those of you who haven't yet gotten to this, The non-delegation doctrine is the principle that Congress can't delegate its legislative power to executive agencies. It was articulated as early as by John Marshall. And in 1935, the Supreme Court struck down two federal laws, both part of the National Industrial Recovery Act, under the non-delegation doctrine, ALA Schechter Poultry v. United States and Panama Refining v. Ryan. But since 1935, no federal law has been declared unconstitutional as an excessive delegation of power. It doesn't matter how broad the delegation is. Every delegation has been upheld. Think of the Federal Communications Act. It authorizes the Federal Communication Commission to, quote, regulate broadcasting in the public interest. Now, the court says if there's going to be a delegation, there have to be intelligible standards to guide the exercise of discretion. But the reality is, every delegation, even without any standards like the one I mentioned, has been upheld. One of the things that I still do every June is lecture to students getting ready for the bar exam. And I always tell them if they see an answer choice on the multi-state bar exam that a federal law is unconstitutional as an excessive delegation of power, it's an always wrong answer. No delegation is struck down since 1935, so they should never pick as an answer that a delegation is unconstitutional. Last term, as you mentioned, the Supreme Court had before it the case Gundy versus United States. It involves a federal statute, the Sex Offender Registration Notification Act, often referred to as SORNA. It makes it a federal crime for a person to cross state lines if he or she is a convicted sex offender. The individual is not registered as required by law as a sex offender. The statute doesn't resolve how this applies to those who are convicted of sex offenses before it was enacted. It left that to the Attorney General. And the Attorney General said it would apply retroactively. Gundy was convicted of a sex offense prior to SORNA's enactment. He was supposed to register as a sex offender. He didn't, so he was convicted of crossing state lines in violation of the statute. The Supreme Court granted review on one question. Is SORNA an unconstitutional excessive delegation of power? Herman Gundy argued to the Supreme Court that this is giving to the person responsible for enforcing the law, the Attorney General, the responsibility for also determining the meaning and the application of the law. That's an excessive delegation. Case was argued in October 2018. It was before Justice Kavanaugh was confirmed. The Supreme Court 5-3 ruled against Gundy. There was no majority opinion. Justice Kagan wrote for the plurality, joined by Justice Ginsburg, Breyer, and Sotomayor. Justice Alito, as you mentioned, concurred in the judgment. Justice Gorsuch wrote a vehement dissent, joined by Chief Justice Roberts and Justice Thomas. Justice Kagan said twice in her plurality opinion, this is an easy case. And she used the word easy twice. She said, we haven't struck down any delegations since 1935. We just require intelligible standards. Intelligible standards exist here. Congress wanted the law to apply as much as possible, and that's what the Attorney General did. And she said, if we were to strike down this, dozens, hundreds of federal laws would be vulnerable. And she gave examples of laws that use things like the language, regulate in the public interest. Justice Alito wrote a very short, enigmatic opinion concurring the judgment. He said, if there were a majority of justices today who wanted to reconsider the non-delegation doctrine, I would join them. We don't have such a majority, and I believe the plurality is applying the laws that's existed, so I'll join them. Justice Gorsuch in his dissent said, revive the non-delegation doctrine and do it today. Here's the puzzle. If Justice Alito joined with Gorsuch, Roberts, and Thomas, it would have split the court 4-4. One of the things that the court does when it splits 4-4 is it can put the case over for re-argument when there's a ninth justice. There was actually a case last term, Nick versus Township of Scott, Pennsylvania, that was argued when Justice Kavanaugh hadn't yet been confirmed, and then was re-argued when he was president. It was 5-4 with him in the majority. Why didn't Justice Alito just create the tie and have it put over for re-argument when Justice Kavanaugh joined the bench? Especially as there's every reason, based on his opinion in the D.C. Circuit, to think that Kavanaugh is going to join with the conservative justices. Here is my guess on this. And I'll admit I have no basis for it. It's my guess. Gundy is about the Sex Offender Registration Notification Act. It's about sex offenders crossing state lines. That wasn't the place where Justice Alito wanted to take a stand in favor of striking down a federal law, especially after the Kavanaugh hearings that were about sexual assault. This wasn't the case to do that. But Gundy's lawyer decided to do something unusual and asked the Supreme Court to reconsider its decision based on Kavanaugh now being present. The Supreme Court never grants reconsideration. Well, Gundy's motion for reconsideration went to the justices at their conference at the end of September, and they didn't take any action. And then it was relisted for the next conference, and they didn't take any action. And then it was relisted for the next conference. And they kept doing that until November 22nd, when the court denied Gundy's motion for reconsideration. Justice Kavanaugh did not participate, but he issued a short opinion saying that the court's going to need to deal with Justice Gorsuch's historical analysis in another case in the future. I think there are 5 justices now to revive the non-delegation doctrine. When I taught this in my constitutional law class a couple of weeks ago, I told my students, if your summer jobs and your client loses something relative to a federal administrative agency, Securities and Exchange Commission, NLRB, suggest that they might want to challenge the law on non-delegation grounds. This is going to be full employment for lawyers, because I think they're going to open the door to challenges to hundreds, thousands of federal laws that are broad delegations until they decide what's too much with regard to a delegation. So, long answer to a short question, but that's what it's about. Please.
Yeah, in 2014, you stated that that you believe that John Yoo should be prosecuted. Has that opinion changed since becoming dean of UC Berkeley?
If you look at my CV, you will find an article that says that John Yoo should be prosecuted as a war criminal. John Yoo, as you may know, co-authored with Jay Bybee a memo that said that the president was not obliged to follow a federal statute and treaty prohibiting torture, that the president could redefine torture in a way that was quite limiting, saying it had to cause death or failure of major bodily organs and pain accompanying it. Many believe that the memo written by Yoo and Bybee it was what led to torture. If you read the Jane Mayer book, The Dark Side, which is a very powerful book describing the torture that was done, it very much links what happened to the Yoo-Bybee memo redefining torture. I believe that the Obama administration made a mistake in not prosecuting those who were responsible for torture. I think there should have been some truth and reconciliation process. It didn't happen. It's not going to happen now. But my view is in print. Please.
I was wondering what your views were on the idea floating around of adding or subtracting more justices to the bench.
As I'm sure everyone here knows, the number of justices on the Supreme Court is set by statute, not by the Constitution. It's gone from 5 to 10 over the course of American history. 9 is a historical accident. In the late 1860s, there were 10 justices on the court. Isn't it hard for us to imagine now they're wanting to have an even number of justices? But there were 10 justices. And Congress did not want Andrew Johnson to pick a justice for the court. So they simply said the next time there's a vacancy, we'll go from 10 to 9 and not fill that vacancy. And so it's been 9 ever since. You know, if you study constitutional law, President Franklin Roosevelt in the mid-1930s proposed expanding the size of the Supreme Court. It was denounced at the time by Democrats and Republicans. It became unnecessary because very quickly one of the justices, Owen Roberts, who had been voting to strike down New Deal laws and state and local laws, changed his position and began upholding them. My position is that if the Democrats win both the presidency and each House of Congress in November 2020, they should seriously consider expanding the size of the Supreme Court. But I would hope that candidates for the presidency would not talk about it prior to that happening. My reasoning on this is I really regard the Merrick Garland seat as a stolen seat on the Supreme Court. Prior to 2016, 24 times in American history, there had been a vacancy during the last year of a president's term. In 21 to 24, the Senate confirmed, and 3, the Senate didn't confirm. But never before had the Senate said, no hearings, no vote. And I think to offset that, I think the Democrats should seriously consider adding 2 more seats to the Supreme Court. Now, there's an argument against that that's powerful. If the Democrats do that in 2021, if the Republicans take the White House and both houses of Congress in 2025, then it's going to become 13 seats, and there'll be no stopping point. And yet, I still would take that risk, assuming the Democrats have a consensus in favor of doing so. I'm not sure such a consensus will exist. I know too many liberal Democrats who say that's court packing, that's not a good idea. But if the Democrats could get a consensus for it, I think it should be seriously considered. But I would hope the presidential candidates wouldn't talk about it now. It's premature. What's the odds that the Democrats are going to win the presidency and both houses of Congress? And I worry that it does nothing but give an incentive for people who might not otherwise vote to turn out to vote for President Trump. The number one reason that people gave for voting for President Trump in November of 2016 was the Supreme Court. The CNN exit poll, 54% of Trump voters said that the Supreme Court was their number one reason for voting for him. So I think that it's certainly something to think about, but nothing to worry about right now.
We have time for one more question.
Okay. Okay.
I can't remember the name of the case, but there was a case that was up last session dealing with land in Oklahoma. There was tangentially a murder case related to it where essentially they figured out that there is some dispute over if the land, half of the land essentially in Oklahoma belongs to the native people, the Cherokee people there, or if it's now property of private citizens or the U.S. government, and it's up for re-argument this session.
The case is Carpenter versus Murphy, and it's a fascinating issue of whether or not what's a large amount of land in Oklahoma should be regarded as tribal land so that there isn't jurisdiction for the state of Oklahoma to prosecute somebody. The justices split 4-4 because Justice Gorsuch was recused, and they put it over for re-argument, but they didn't schedule re-argument, which was really strange. Now, it was also strange that they would put it over for re-argument when it's 4-4. It's not like there's a new justice coming on the court, and if Justice Gorsuch was recused last term, he's recused this term, and why believe that any of the justices on either side are going to change their mind? Well, the Supreme Court, about a month ago, granted review in another case involving the same issue, and so I think that's how they're going to deal with it. And it's yet another of the blockbuster cases on the docket for this term. And with that, I'll say thank you for coming today and thank you for having me.